Good evening. This is Rahul Reddy. Along with me is Emily Neumann. We're business partners in Reddy Neumann PC. Reddy Neumann PC does bring in every week on Tuesday from 5 to 6. We bring in business immigration updates. Emily, what do we have today?
All right, so today we have some new data that is provided by Mother Jones and Reveal in a really in-depth article that talks about all the ways that the Trump administration has really been impacting high-skilled legal immigration and building an invisible wall. Some of the revealing data is about the higher number of court cases that are being filed on behalf of employers, especially for H-1B visa denials, and what the statistics are for how often USCIS is successful in those cases versus the employers that are bringing the lawsuits. We also wanted to just go over a question that comes up quite often is how can you benefit, or when can you benefit from an old employer's I-140 petition? I think there's a lot of, rumors or misinformation out there. Some people think that you have to stay in the same type of job and can't be sponsored for a new job, or can't use it if you are changing employers. So we want to dispel the myths there and give you the accurate information about when you can and can't use an I-140 petition that's approved with an old employer. And I also want to talk about a very common question we get these days, especially over the holidays, is when is it okay to travel when you have an application pending, particularly an extension application, whether it's an H-1B extension, H-4 extension, L-2 extension, any EAD extension. What is the potential impact of traveling while those are pending? When can you come back while it's pending? And all of that details. And of course, we're here to answer your questions.
One of the things that has been presented, Emily, by the Mother Jones article, well-written, thoroughly investigative article that has been there, was that the amount of cases that have been filed through litigation because of the H-1B denials has gone up by more than 20 times than compared to in 2012, 2013 or so. What do you think is the reason why people are going to court system instead of getting the approval with the USCIS?
Well, I think that for many, many years, immigration lawyers were not litigators. And so when you get a denial of an immigration case, the common, strategy was refile the application or file an appeal with the AAO or file a motion to reopen with USCIS. But more and more often, those recourses are really not that great anymore compared to litigation. So we're seeing more and more arbitrary denials that are happening than ever before, and we're seeing better results through litigation than through filing an appeal or refiling. And the word is getting out. So the number of people that are fighting these arbitrary denials in court has skyrocketed just from even 2 years ago. I mean, looking at the graph in the article, it's like this, and then it goes straight up from there just in the last year or two. And I think the results that people are getting from seeking assistance through the courts is also the reason why more and more people are choosing it. We're seeing cases getting reopened and approvals issued. We're seeing much faster response times. The court is able to potentially stop someone from going out of status while the case is pending, which an appeal doesn't do. So there's a lot of benefit to litigating versus the other options that we used to do.
Do we have to wait until we go to the administrative appeals unit once the denial comes in, get a denial there before we go to the federal court? Or can we directly go to the federal court?
Yeah,
what's the timelines for all these things, Emily?
There is kind of a overall idea that you have to exhaust your administrative remedies before you can go to federal court. However, in the typical I-129 denial situation, I-539 denial, it is not mandatory for you to first go to the administrative appeals office and then get that denied and then go to court. So as soon as you have a denial, your option is to go to court or file with the AAO, file an appeal. You do not have to wait and go through the AAO first. Now, once you do file a lawsuit, the government then has 60 days to respond in court to the lawsuit and tell the court whether it is going to try to dismiss the case, whether it's going to fight the case, or what we most often see is rather than fighting the case at all, they simply ask USCIS to reopen the petition, issue an approval, sometimes issue a request for evidence, and then an approval, and then we dismiss the case. All of that typically happens within a 60-day window after we file. Compare that to going to the Administrative Appeals Office, where it's a minimum of 6 months from the time the case gets to the Administrative Appeals Office. First, you file with the Service Center. The Service Center takes 30 to 60 days to review and then gets forwarded to the AAO. So you're looking at really a minimum of 8 months. And then if the AAO actually reverses the decision, they remand it back to the Service Center, then the Service Center takes its sweet old time to actually move forward on the case. So it could be close to a year before you actually get a result out of
Is that the
an appeal.
maximum time you're telling me?
No, it could be longer than that as well. So that is one of the benefits of litigation is we see a much faster result in that situation.
And cost-wise, I mean, when clients are, if I'm an immigrant, I came as an immigrant, so if I'm looking into what's the difference between if I were to go with any law firm, and not just ours, but any law firm, with the appeal process and the litigation process, how much is the difference, though?
Yeah, I mean, obviously fees vary among different law firms and attorneys, but I would say the relative cost of filing an appeal versus filing a lawsuit, the lawsuit's going to be a little bit more expensive, but not like
it's not going to be
it's
3,
not
4
as
times.
expensive as
It's
what
not
people
3, 4
think.
times or 4 times
Right.
expensive. Yeah.
Yeah.
And the good part about Reddy Neumann PC is that we do a flat charge for the court cases also. I know we are immigration lawyers and the litigation lawyers, they always charge hourly. So it's an open-ended contract, but in our office, we have decided, since we've been in business from 1997, mostly we stick with the cost based on the per litigation. It's not open-ended with our office. We try to convert that, and that's a good part that we provide for our services. Emily, on this Mother Jones article, it also said that Trump is not only trying to build the walls, but he's also building the invisible walls. Can you explain what this article means? Do you feel that, in the past 2 years, 3 years, do you see the difference between the previous administration and the previous administration to compare to this administration?
Yeah, definitely. I think that as far as blocking legal immigration, it's a much more nuanced approach. You're not sitting here actually building a physical wall, but they are still blocking legal immigration by increasing processing times, making the hassle factor way worse. Now we have these biometrics requirements for I-539 applications. That delays everything. You've got the social media questions that were added to the DS-160 visa application, soon to be added to the 485 and the N-400 for citizenship applications. Processing times in general are long. You can't get a visa interview appointment. They're backlogged there. That's just the processing hassles that we're seeing. On top of that,
forget about the short-term approvals.
Yeah, then you've got a huge increase in denials, huge increase in RFEs, huge increase in shorter approvals, sometimes valid for just a day. Even if it's valid for 3 months, you can barely use it if you need to go for visa stamping because you can't get an interview in time. So it's practically a useless approval. So those are really the way that the administration is blocking legal immigrants, building an invisible wall, because you don't hear about it, because it's not as high profile. You don't hear about it in the media because it's not an actual wall and there's no big fight with Congress over funding for it. He's just doing it all kind of under the radar. And
so, Emily, you said that delay of a lot of cases, denials more, short-term approvals there. Is there any change in the law after this administration comes in to do all these things, or is it they're doing it?
Yeah, that's what's really interesting about all of this is no change in statute by Congress, no change in regulation by Department of Homeland Security other than the change to the H-1B lottery process. But all of this has been changes in interpretation of existing law to make everything much more difficult, and then just making everything as cumbersome as possible so people will give up.
So it's like, trying to make the legally abiding immigrant people to self-deport themselves is the way that this administration is trying to do. Emily, on the old I-140 approval, a lot of people are on the assumption that an I-140 approval is approved in 2000 and when they left the country, they can still use that again to get the H-1B or port the date?
Yeah, so the basic rule is after January 17th, 2017, once your I-140 has been approved for 180 days, it remains valid even if you leave the country, even if your employer withdraws it
After January of 2000?
after January 17th of 2017, but only for specific purposes. So having that old approved I-140 that meets those requirements, valid, approved for 180 days, not withdrawn before January 17th, 2017, allows you to continue to get H-1B approvals beyond the 6-year limit, even with any other employer. It does not have to be with the same employer that sponsored your I-140. It can be in any other type of job that qualifies for the H-1B. It doesn't have to be the same job or similar job to qualify for that. So you can keep getting those H-1 extensions even when you're outside the country. You can retain that priority date when your new employer files a new labor certification in I-140 for you in the future, and your spouse is eligible to obtain the H-4 EAD and keep getting those extensions even if the old I-140 is later withdrawn.
And they can also use that to port the date to the new employers, right? Okay, and we promised to address the issue of travel while it's pending extension. So if I am on H-1B and my I-94 is expiring in February of 2020, my passport visa is expiring in February 2020, and if I want to visit India for my Christmas vacation and come back before my passport visa expires, while my H-1B extension is pending, can I travel?
Yes, you can, because your visa stamp is still valid and your petition and I-94 have not yet expired. So you did the good thing of filing your extension early, because we talk about that all the time, is to plan for the extra delays of RFEs, plan for the possibility that you might get a denial. So file early so that you can overcome those obstacles if they happen. But if you do file early and your underlying petition has not yet expired, your I-94 is valid, your visa stamp is valid, you can travel and come back in before that previous petition expires. Now, the thing to be aware of is that when you come back in, you're going to get an I-94 that still matches the date of the soon to expire petition. And you need to update your I-94 number with the pending application so that your I-94 can be issued with the new number on that approval. So there's a little bit of extra steps that you want to take to make sure there's no mismatch in I-94 numbers. But other than that, you can travel with that in that type of situation.
In the type of situation, same thing with L1, L2, H4s also, isn't it, Emily?
Absolutely.
What if I were to file a change of status from H4 to H1B? I had a H1B before, I filed for change of status right now. Can I now travel outside the country and come back, and it's still the same story?
Different scenario completely. So the difference is between an extension request versus a change of status request. An extension request, when you travel while it's pending, it does not abandon the extension request. The petition will still be processed. A change of status, when you leave while it's still pending, it is automatically abandoned, regardless of whether you want it to be or not. And so your change of status request will automatically be denied. Now, if in that example you've given of an H4 changing status to H1B and you travel while it's pending, the H1B petition itself can still be approved, assuming all the requirements are met, but your request to change status will be denied, so your approval notice will come without a new I-94 card. At that point, you can then apply for the H-1B visa stamp at the consulate and then come back into the U.S. in H-1 status. Now, that's different if you are, for example, filing a change of status from F1 to H4. In that situation, if you travel while that's pending, the whole application gets denied, not just the change of status, because the application itself is the change of status. There's no separate petition. So in that situation, your application gets abandoned, change of status is denied. You have to then apply for the H4 at the consulate instead. So yeah, so that's the main difference between the two, is whether it's an extension of stay or a change of status. Those have different outcomes.
Let's go to the Q&A assembly.
All right. Yep.
One advice that came from admin NRIs that our charges are too high for the student and small employees. Please understand and try to consider it to make it low. We will try, admin NRIs. One thing is that previously our charges were very low, obviously. Recently, since this administration came in, the RFEs have gone up, the denials have gone up, the time processing has gone up. So we have to, the workload that is involved has gone up. We used to see a denial ratings of approximately 2% previously. When it was 2%, it was fine. I mean, we could. But when it starts going up significantly higher, from 2 to 20% in some cases more, because we do represent a good number of consulting companies also, then we have to pay a lot more attention to the case. And it's not like a cookie cutter that we cut and paste it. There are a lot of things to be considered, any factor that may be effective. So definitely it involves a lot more work. We have cut down filing the number of cases because the time to do a case has gone up very significantly. Unfortunately, we have to increase the fees, especially when we are playing with the lives of the individuals. We really don't want to cut down the price and cut down our services. And because I, as an immigrant, I at one point of time was an H4, my wife was an H1, and we eventually got the green card. I mean, so back in those days, things were smooth. But even if they were not smooth, I wanted a good lawyer to be reviewed. I want a lawyer to spend good time on it. I just don't want it to be just cut and pasted and send it out. So I myself, at the time when I was there, I did not hesitate paying more money. I've gone through the process. So if one case gets denied, the effect of it is devastating. I mean, right now, if a main applicant is an H1 and H4, if the H1 gets denied for the extension transfer, or even amendment, sometimes the amendment plus extension, they have to leave the country. They have to sell the whole house. Their children are going to school. So it's very tough. We have to work very hard on getting these things approval. So unfortunately, we will try, but we may not be successful in it based on this administration. Our office, we have tried to club the H4 EADs to cut down the cost. If we wouldn't have cut down we wouldn't have clubbed the H4 EADs. I mean, we could not even file these petitions with the federal court because the cost is too high. And we are the only persons that we know of are doing the H4 EAD delay litigation. We're also clubbing the applications for the short-term approval so that we can get these things clubbed together and file one application, get these things approved. We're trying to do all these things. We have also changed with regards to having a flat fee for the litigation. You know how it works out in the litigation. You go, it's an open-ended contract. You don't know, it never ends. But we have decided that, okay, let's do, specialize some lawyers only for the litigation. Hire the best lawyer that's there available in United States. Only he will be supervising our things from Washington, D.C. and so very best guy, and do all the groundwork for him so that he can review our file to cut down the cost, at the same time not to cut down the quality of the litigation that we are doing. We're trying to do it, but when it comes to the case, I've been there. I didn't got any of them denied. My lawyer was very good. Fortunately, it was Clinton administration at that point of time. So yes, but now it's Trump administration. We're trying to be the same as our lawyer is back when I got my green card. Charge a little bit high, but make sure that things go through smoothly. Are we fortunate enough to get 100% approval, Mr. Admin NRI? No, we are not. We are not fortunate enough to get that on 100%. We have our setbacks, we have the denials. Every week, as a lawyers, we meet in an office together, we go through the denials, we come with the new solutions, and it's an ongoing process that is there. Previously, when the denial used to come in, monthly, once or twice we get it. It was rare. Right now, it's weekly, once or twice discussions on the denials, new strategies. What is the USCIS? Okay, they denied like this. What if we argue like this? Can we make a sense of those things? But sometimes when we argued the other way around also, we got hit too. So we have to be very careful. Too much time is getting spent on these discussions. So that's the reason why we were unable to decrease, but we'll try as much as possible.
Mr. Bravos from YouTube is trying to renew his F1 visa at the consulate, and the application has been rejected 3 times under Section 214B. That is for immigrant intent. And he wants to know if showing real estate ownership would help. What strategies are there? So I'll first say that you could show up with a mountain of documents showing bank accounts and real estate in your home country, and it is not going to make a huge difference in many cases, because the reason that the 214B is happening is based on your verbal answers to the officer. They're not going to come out and ask you, do you have immigrant intent? And you say yes or no, and that's why you got the denial. They have very kind of backwards, back-ended ways, roundabout ways to get the information out of you, and it's based on your responses to those questions, most likely that they're finding that they think you are likely to be an immigrant and don't have the intent to return home at the end of the F1 stay. So you're mentioning that this is a F1 renewal. That, number one, triggers to me, well, how long have you already been in the U.S. on F1? If you've already been here for 5 years, the consular officer's really going to question, now you want to come back for 5 more years. Are you really ever going to go home at the end? If you didn't go home already at the end of this stay, that is more likely what is triggering a 214B. And other similar answers about where your family is located. Is all of your family in the United States, or close relatives? Do you have any U.S. citizen close relatives that could potentially sponsor you? So even if you bring all of this documentation to prove otherwise, it's really, the documents are of secondary importance. It's all about your answers to the questions, what your body language is like, your believability to the consular officer, and what your true intentions are.
Preet has this question. If I change the citizenship, will it make a difference in the I-140? What he meant to say is that, will it become current if I change the citizenship to Canada? Unfortunately not. Otherwise, I would have, told all my clients to pay $10,000 and get a passport. Well, I'm not telling any illegal things. There are some countries that give passports for $10,000. It's completely legal to do so. Of course, India does not allow dual citizenship, so they will be only citizen of that particular country. That doesn't make any difference. To be considered as a different than Indian, you must have been born in that country at the time of your birth. You must have been, even if you're not a citizen of that particular country, let's say it's a United Arab Emirates or Saudi, if you're born there, you may be considered of that country. But if you change the citizenship, no, it won't be considered that, you won't be considered as a Canadian. For the purpose of the green card purposes, you will always be considered as a Indian. For the purpose of the TN, non-immigrant visas, and e-visas, you will be considered as a Canadian though.
So in that situation, if someone changes their citizenship after their I-140 is approved, do they have to amend their I-140?
No, they don't have to amend the I-140. They can explain that at a later date that they changed the citizenship. They don't have to amend the I-140.
Priyanka from Facebook recently got her H-4 approval, at least online. It's showing that it was approved November 29th, but she wants to know how long it will take to receive it because it hasn't come in the mail yet. Anywhere from 1 to 2 weeks. It's not a super long time, but if you haven't received it, you have to wait 30 days before you are able to actually follow up with USCIS in case it got lost in the mail, but it should be coming anytime now.
Srinivas Salladi has this question. His wife is an H-4 EAD. His wife is thinking that it's a H-4 EAD. He's planning to apply for EB-1A, not EB-1-2, EB-2 NAW. He has an option of either going for EB-1A or O-1. Will it cause any, if she gets an O-1 visa, can she continue on the H-4 EAD? The answer to the question, Srinivas, is no. Once she gets the O-1 visa, H-4 EAD is not valid. Obviously, if she gets the EB-1A approved, though, it's not touching the H-4 EAD. If the EB-1A is approved, she can continue with the H-4 EAD. But once she gets, if you choose to go for O-1 visa, then you cannot use the H-4 EAD.
Jay Raman from YouTube wants to know if he can switch from an analyst position to a developer position on H-1B as long as the wage level is met. Does this cause any kind of RFE or denial? Does USCIS review the previous job history? So every petition stands on its own, and if you qualify for an analyst position and that analyst position is considered a specialty occupation and all of the other requirements are met, you can get an H-1B approval as an analyst. You could also, just as easily, if you qualify as a developer based on your education and the developer position qualifies as a specialty occupation and all those requirements are met, you can get an approval as a developer. There's no reliance, just because you were an analyst before doesn't mean you have to be an analyst at another job, and vice versa. You can change to different types of jobs, any kind of job, as long as you qualify for it based on your education and the job qualifies as a specialty occupation.
One question that came from Mother Aurora is that the EAD litigation that we are doing, is that applicable for GCEAD or is it only for H4 EAD? The EAD litigation that we are doing, the one which is very popular, like grouping together and all those things, is only for H4 EAD and L2 EAD. When it comes to the GCEAD, we are contemplating to file. It might be we have to file an individual application. We are taking those cases too. But a lot of the cases, Mother, what happens is that since, if it's an initial EAD filing is when you might need the litigation. In the GCEAD, if you have an extension of the EAD pending, you are allowed to work up to 180 days once your EAD expires. So you can continue working. But if it's the first time that you're filing for GCEAD, you may need to litigate. Otherwise, you file well in advance and then you have a 6 months window, you most probably don't need to litigate.
Chanuru from Facebook wants to know if you can travel if you have an H-1B transfer that is pending but a valid visa stamp. So if you have a valid visa stamp from Company A and your I-94 with Company A has not expired, and you have your receipt notice from Company B and you've joined Company B, technically, yes, there is a guidance memo that says you can travel in that situation as long as you will return before your visa stamp and I-94 expire. If you're going to wait and return after they expire, you're going to have to stay outside the U.S. till your transfer gets approved, then get the new visa stamped and come back into the U.S. But yes, that is possible.
One question that came from Krishna is that he has a DWI pending. Will it affect his H-1B extension that he's going to file within the United States? Krishna, you have to mention that the DWI, but as far as the extension is concerned, it should not affect your extension. Please be careful when you're going for stamping though, it does affect it. You have to first make an appointment and you have to go to a psychological evaluation. And it's taking about 5 to 8 weeks right now to get through the entire process on top of the appointment process. So if you were to go for stamping though, I would advise strongly to make all arrangements well in advance. If you get stuck there, what are you going to do? So at least 5 to 8 weeks is the time that it's going to take for you to complete the entire process though, if it's a DWI. For extension within the United States, we haven't seen any problem yet for the DWIs though.
Nariana from Facebook has a follow-up question to our discussion on the I-140 and retaining that old priority date. He wants to know if the old employer has to be involved in that porting process, or do they have to help with that process? And the answer is no. The old employer has no part in the process. The new employer has to file a new labor certification. Once that's approved, when you file your new I-140 with your new employer, all you have to submit is a copy of your old I-140 approval notice, and they'll port that date onto your new I-140 approval notice. The old employer has no interest in that, doesn't have to do anything for it to happen.
Question that came from Akhilesh from YouTube is that his H-1B transfer is pending with multiple employers. If the transfer gets denied, will he be out of status on the day his I-94 expires, which is November 30th, or on the day he got the H-1B transfer rejected? Assuming that you have filed the transfer before November 30th, Akhilesh, you will be considered to be unlawfully present after the rejection, not from November 30th. So if you file a transfer to Company A to Company B before your I-94 expires, and let's say your H-1B gets rejected in September of 2020, it is the September 2020 from which period of time your unlawful status counts.
Vijay Prakash from YouTube mentioned the significant increase in filing fees that DHS is planning for all different types of applications and wants to have an overview of those fees that are coming up. I don't have them memorized, but if you go to immigrationgirl.com, one of my very recent blog posts was on that specific topic, and it gives you the exact current filing fee, new filing fee that's proposed, and what the percentage change is. Yes, there are some significant ones. For the I-129, one of the new concepts is actually having a different filing fee based on the type of visa classification. So H-1Bs will have one filing fee, L-1s will be a higher filing fee because those take longer to adjudicate and require more work involvement. But yes, you can get those updated fees and what's being proposed at immigrationgirl.com.
I have an interesting question that I need some help, Emily. But before I go to that interesting question, I want to answer this simple question. Neeti Sharma was been here on student visa, and she has been working here for 9 years. She has an I-140 approval, and she got the H-1B approved, and she's going for stamping. Will the immigrant intent will be a problem for the H-1B? Absolutely, it's not going to be a problem, Neeti, because the immigrant intent is only a problem for F1, and you are going for H-1B. Just because you're going for after 9 years, immigrant intent is not a problem. H-1B is a dual intent visa. Even if you have an intent to immigrate into the United States, which you already expressed through your I-140, it's not going to be a problem. In the first discussion, what Emily was having was that it was a student visa. That's the reason why she was pointing out. That is completely not applicable. Now, here is a $1 million question for you, Emily. How do you explain the employer-employee relationship with multiple layers?
Well,
this is from Ravi Raja from YouTube.
Yeah, you have to submit documentation from every single layer involved. That includes the contract between every layer and the work order or statement of work or PO between every layer, and a letter from every company involved in the layer. And all of those documents should support a finding that your actual employer sponsor is the one that has the right to hire, fire, pay, supervise, and otherwise control your work, even though you're at the third-party site through multiple other layers. That's part one, is by just showing all of the documentation between all of the companies involved. On top of that, your employer needs to submit documentation that proves how exactly they are supervising you while you're at that third-party site. So that's where they look to what the performance review process is, what is in your employment agreement or offer letter, what's in the company handbook, what types of policies are you required to abide by when you're at that third-party site. Does the company make you record your time so that they can run your payroll? Does the company provide benefits? What's the organizational chart of the company that's sponsoring you? Who is in the chain of command that you have to report to within your company, not at the client site? All of those documentations are necessary these days in order to overcome an employer-employee relationship question.
And at this point of time, we are saying about 15% of the H-1Bs, or 10 to 15% of the H-1Bs getting denied with the employer-employee relationship. Yes, Emily did point it out that she needs to have all the letters from everybody, contracts from everybody. When it comes to the field, though, it's not that way. I mean, you can't get the letter from sometimes the end client letter. Sometimes you don't, because of the confidentiality, there is no contract between a particular vendor to the end client. What do we do in that situation?
Well, my initial recommendation is to find a different project that is cooperative in supporting your visa application. If that's not an option, I mean, your only option is to file with what you have and hope for the best. There's just no alternate documents that USCIS is accepting, but in the event that you get a denial, we are seeing when we fight those denials in court that we're getting the cases reopened and approved.
Yes, that's one Emily has pointed out, but there are a couple of other preventive measures, Ravi, is that try to get that if you're a new quota person where you're filing on the new quota, if it gets denied, we would strongly recommend to go through the litigation process. But if you are filing for an extension, transfer, or any of those things, though, you may want to get the decision before your I-94 expires. So because if you are filing an extension, if your I-94 is not expired, you have multiple chances going to the USCIS. You may want to change the employer. Those are other chances that you'll get. Even when you're applying for a transfer from company A to company B, Ravi, what happens is that if you get the H-1B transfer denied before your previous H-1B I-94 validity expires, you have a great chance at that point of time to go back and file one more application with the same company, because the 60-day rule that was passed in January of 2017, this is one of the rare regulations that came out in the Trump administration, which was actually proposed in the Obama administration, was that you have a 60-day grace period that's been allowed for you. So we have used that 60-day grace period even when you're moving from company A to company B. That's another preventive measure that you can. You may also want to consider, for example, if your I-94 is expiring, you file for the transfer application, you don't get the result. Let's say if you have an option of H4 plus EAD, I may want to throw another application there for you just for H4 EAD, just in case if you get the denial. With the denial ratings of approximately 20+% of what Mother Jones has reported right now for us, it's better to be very cautious when you're doing this. Yes, it's good to get all the documents, as Emily has pointed out, but if you don't have it, I want you to sort it out all the alternative plans that you may have, like what I discussed.
Sagar from Facebook is planning to go for stamping after he filed an H-1B transfer not too long ago, and his wife is also going for H-1B stamping for the first time. She has an approved I-140, and he wants to know what things should they take care of through this process. So first, you should both thoroughly read the H-1B petitions that were filed on your behalf. You would be amazed at how many people cannot articulate what their job duties are in accordance with what has already been submitted to the Immigration Service, and the consular officer does have access to that entire petition in the PM system. So many of the questions that they will be asking are to verify that the information in the petition was in fact accurate at the time of filing. So that's the first thing. Second, when you're filling out the DS-160, make sure it's accurate. When it asks for all of your education history, put all of the schools that you attended, not just the ones you graduated from. We saw people got into trouble, got their visas denied for misrepresentation because they didn't list some of the schools they attended because they didn't graduate from them and thought they didn't have to, and it turned into a misrepresentation finding for them. On your prior employment history, make sure that it accurately reflects what you actually did, the job titles and the duties, and it should also match with what's in your prior immigration applications. We've seen a few times where in the future some information provided in the DS-160 is used to give a notice of intent to deny or revoke an I-140 years later because they put different job experience and histories, different dates, different titles for their prior employment experience. Those would be the main things that I would say is read the petition, make sure that it accurately reflects what your job is and the job duties are, know about your company, where they're located, kind of common sense stuff, but you'd be surprised at how many people get tripped up over simple things like that.
Did you address the Facebook and the
no, great point. Make sure your social media is actually accurate. On your social media, on Facebook, if you're married but you're applying for an H1 and H4 and your Facebook says you're single, maybe that will call into question the validity of the marriage for the H4 holder. Same thing for employment on your LinkedIn. Do you have, if you're in third-party placement, are you listing the end client as your current employer, or is it your employer that's your actual employer? So make sure that your social media is accurate as well, because again, they do, with the DS-160, they ask for all of your social media handles, so very easily they can look up your LinkedIn and see if it is matching what you listed on your DS-160.
Vijita has this question from Facebook. My son and I have filed for H4 plus H4. My son is a dependent on my H4, and I got an opportunity for H1B, and she got her H1B approved, and she withdrew the H4 of her. She didn't realize the son is a dependent and her son's H4 also has been withdrawn. One thing is that if your kid is under 15 or under 18, I forgot the exact amount. I want to be conservative right now. If your kid is under 15, you definitely can file a non-protunct H4 application. I'm not expecting much problems in filing a H4 independently because a time period for unlawful state will not hurt a person who is under 15. I may be wrong in the age, it may be 18, but at this point of time, I will use 15 years age, that if it's more than 15, you may want to contact the lawyer. The other option is that the kid can leave outside the country, get the H4 stamping and come back into the United States. These are the options that I would suggest though. It's called non-protunct. That means that please excuse me for being out of status. That's normally for a kid. We have never seen any rejection at this point of time. But I would still advise maybe it's better for you to contact a lawyer when filing the H4 application for your kid. Aruna has this interesting question, Emily. We need a little bit discussion on this one. She is in the 4th semester of her day 1 CPT college. She has got her H4 plus EAD. Is it good to work on H4 EAD or does she need to go for F1 stamping in India? One thing is that recently a lot of articles were being published in Fox News. We have had Breitbart, we have issues and a lot of things that were published in the last 4 or 5 days. We have 2 presidential candidates of the United States who commented on these day 1 CPT colleges, how the USCIS is actually luring the people in joining the day 1 CPT and then deporting them. And that's what the whole discussion of the presidential candidate was. Our law firm has been quoted many times by these Fox News and other things, is that we from the beginning considered the day 1 CPT universities as bad. You go back to the history 2-3 years and come back, day 1 CPTs are bad. For your advice right now, yes, stay on H4 EAD. They're not going to give you F1 stamping when you go to India for the day 1 CPT. And any comments on this day 1 CPTs that's going on in the Fox News and the presidential candidate survey?
Yeah, I mean, so what's going on in the news is relevant to the University of Farmington, a fake school that was created by ICE and lured in about 600 students, and they, either were detained, put in removal proceedings, deported, or self-deported, voluntary departure. I think that there are a lot of we have a history of other schools that were providing these kind of benefits, maybe not following proper procedure and getting shut down and students getting into trouble. Farmington is not the first one, even though that was a fake school. The University of Northern New Jersey was also a fake school, but we had legitimate real schools. I don't know if I should say legitimate schools, but
they're
real
not legitimate.
Schools
that were giving day 1 CPTs. Silicon Valley University, Tri-Valley University, and a couple of other universities.
Northern Virginia?
Yeah, a couple of other universities that got into trouble. Now we have some universities that are giving, namely Cumberland University and Campbellsville University. I don't know how they are giving. Every 2 weeks the college starts. They give work permit on the day 1 you join. There is no admission requirements. There is no requirement you have to go to college except for 6 days in a year. That's how many days I used to go when I was in the law school each week. When something is looking like a duck and it's walking like a duck, it's speaking like a duck, it's probably a duck, guys. I mean, if something is sounding like a university, but it's saying that you can get admitted whenever you want, the college starts whenever you want, you get the work permit whenever you want, there is no admission requirements, you don't have to go to college. Does it looks like a university to you? I mean, where does it sound university to me? We have requested many times the USCIS and ICE to shut down these universities, but they're not shutting down these universities. We believe truly that the only reason why they are not shutting down these universities is to accumulate all the people and strike them at once. like the way they did it with the University of Northern New Jersey, University of Farmington. Those are fake universities, but Silicon Valley and Tri-Valley universities also, they striked on those things. Both of those universities, authorities are in jail for at least for a long period of time. It may still be sitting in jail. So my recommendation is that if you are joining Day 1 CPTs, please consult a lawyer. Actually, no need to consult a lawyer. It's absolutely a fraud, Day 1 CPTs, according to us. I mean, there are very rare scenarios. If you are a postdoc and you're going to a good university, like for example, University of Texas, and you're doing some high-level research, maybe it may be allowed if you're working in the university, not outside campus. Maybe it's allowed, but I would recommend that don't join the Day 1 CPT universities. And if you're already in Day 1 CPT universities, you need to consider whether you're doing a legitimate thing. I strongly advise to consult a lawyer. Emily, on this Day 1 CPTs, have you, the universities promise all those things, they're doing all legal. Now, when it comes to change of status from F1 to H1B, have you seen a smooth transition for this Day 1 CPTs to H1?
No, definitely not. If you request a change of status from F1 to H1 after attending one of these schools, you can almost guarantee yourself getting a request for evidence on maintenance of F1 status. And then whether your CPT time was properly authorized. And many, many, many students that reply back to those requests for evidence with all the documents that the schools provide and tell them to submit end up with a change of status denied and a determination that because the CPT was not properly authorized, they violated their F1 status and you have to leave the country. What's really interesting is when they get these denials, the schools are telling them, no, you don't have to leave. You can stay and continue your F1 program because you haven't been terminated in the SEVIS system yet. But when you get a determination from the government saying that you have violated your status, continuing to stay in that status that you have violated is not a good option. So we've seen denials of the change of status. We've seen people at the port of entry being deported, expedited removal for attending what CBP, I mean, they wrote this in the removal order. You are attending a fraud university, word for word, for one of these schools. People that are applying for the visa stamp at the consulate are receiving denials, being found inadmissible due to misrepresentation. People that attended these schools and don't disclose it on their H-1B visa stamping DS-160 are being denied for misrepresentation because they think they're trying to cover up the fact that they attended these schools. So clearly something is not right with these schools. It's causing a lot of people to end up deported, removed, inadmissible, barred from this country, yet they're still out there and they're still operating and clearly making a lot of money off from these students.
And a lot of people will ask, why is Reddy Neumann PC taking this stance? There are a lot of people that are going to these kind of universities. Let me explain you one thing, guys. There are approximately about 9,000 schools that are authorized to give F1 visas. Only 10 of them, less than 10 of them, are giving Day 1 CPTs. So it's not we are rare, they are rare. So please understand, we are not telling, and you need to go with the basic rules of what a university is. You don't need any magic word from a lawyer. You know the basics. You have gone to the high school. You know what a university looks like. So please understand, don't deviate from the basic rules.
Carlos from YouTube has a question about I-9. So he was previously on H-1 and ultimately received his green card. So congrats for that. And his employer is asking him to complete the I-9 form. He wants to know if that's no longer required now that he's a green card holder. Because of the transition from the H-1 to green card holder, when you last completed the I-9 and did the re-verification, you provided your employer the H-1B approval notice that has a specific end date. Once that end date comes up, even though you're a green card holder now, your employer still has to re-verify because the document that they verified last time is now expiring. Now, when they do that, you're going to fill out your green card information. Once that's done, you're correct. From that point forward, you never have to re-verify because you are a permanent resident. But that very first time when you make that transition, yes, you would have to complete that one more time.
Rima has this question. She is on H4 EAD. Can she take up multiple jobs at the same time? Absolutely you can. That's good. Go at work, make more money, pay more taxes. You are a good immigrant, at least for a lot of people.
Ram from Facebook wants to know if we can apply for multiple H-1B transfers at the same time. So he's working for company A and wants to transfer to B and C and file the petitions at the same time. There's no specific restriction on that, assuming that those two companies are valid job offers. Yes, you can have both filed and they can both be pending at the same time. There's no interaction between the two. Where I would caution people is if B and C are actually filing for the same job opportunity. For example, if you're involved in third-party placement to work at an end client site and company B is filing for you to work at that end client and company C is also claiming they're going to place you at that same project, there's only one job. Only one company has the right to control, has the employer-employee relationship. So that is, I don't think, is a valid way to file two transfers. But if they're two separate job opportunities completely unrelated, I don't see any issue with it.
Surya has this question. He has his I-140 approved. He's working for a non-profit higher education institution. He's an H-1B, but he was never counted in the cap. Can he now move for profit organization? You can, but when you do move, you have to file under the quota only. Just because you have an I-140 approval doesn't mean that you are exempt from the quota. Since you are never counted towards the quota, you still need to be counted for the quota. So you have to only apply in April. You know, right now it's a little bit changed on the rules, which we'll update in the coming weeks. But yeah, you have to apply in the quota. You don't have an exemption. Raj has this question. I'm in H4. Can I join my master's? Not the day one CPT. Thank you very much for not choosing the day one CPT, because we don't consider that as good. With a regular college. And can I get an OPT when my status is on H4? Unfortunately not. For you to get an OPT, you have to be on a student visa. So you have to convert into student visa to get an OPT. Otherwise, you will not be getting an OPT.
Tushar from YouTube wants to know, for the H4 extensions, will biometrics have to be done every year? It took a lot of time this year and is wondering what to expect in the future. So it's not that it has to be done every year, but it does have to be done every time you file that H4 extension. So when you file the I-539, every time you have to do the biometrics. And so, you know, if your H-1B for your spouse has only been approved for 1 year and your H-4 has been approved for 1 year, a year later, yes, you're going to have to file that H-1 and H-4 extension again and do the biometrics again.
One question that comes up from Savitri is that he has filed for the H-4 EAD. Now it says that the G28 has been rejected. Will she get into any trouble? No, G28 will not affect your 76Y. It will be processed under the normal processing. You should not expect much trouble. You can always request your lawyer to submit the G28 again, but it shouldn't affect your 76Y application at all.
Adarsha from YouTube wants to know if there's any way to expedite an EAD extension. His spouse has a job offer in hand. The short answer is no. We've truly found that nothing works. In the past, we used to be able to submit outside normal processing time e-request, or we could do an expedite request, or we could ask Congress or Senator to give us assistance because of the current situation. None of that is working anymore. Literally the only thing we have found that works is filing a lawsuit, and so every 2 weeks we do file lawsuits on behalf of a group of EAD holders that have an extension pending, and usually within about 60 days after filing that lawsuit, the EAD approvals are issued. That's really the only thing that we have found that works.
Good question that came in. If somebody goes to college from H4 EAD and finishes the master's degree, can they apply the H-1B under the master's quota? Assuming it's an accredited and non-profit organization, yes, They don't have to be an F1 visa to apply under the master's quota. Even if you're an H4, you can still apply in the master's quota. Subject to the condition, it's an accredited university and it's a non-profit university.
Sudeep wants to know, if I join a new company with the approved I-140, what happens if my date becomes current and the new employer hasn't started the perm process or the new petition gets denied? Does the old I-140 remain valid? Well, the old I-140 remains valid unless the employer has withdrawn it or it gets revoked for fraud or misrepresentation. But you can only use it to file your adjustment of status if that old job is still being offered to you. Now, when you are with your new employer with that old employer's approved I-140, hopefully you would have received a 3-year H-1B period, and as long as the priority date is not current, you can keep getting 3-year extensions. Once the date becomes current, in most situations you can only get a 1-year extension. And then at that point, if you still don't have the new petition in place or have not been able to file the 485, that's where you're going to run into trouble and not going to be able to extend your H-1B further.
Srinivas Gopal has this interesting question from YouTube. He's asked a question, is the H-1B holder a non-resident alien or a resident alien? For the purpose of the immigration, you are a non-resident alien. But for the purpose of taking the money, the government considers you as a resident alien. The reason is that if you are not a non-resident alien, they don't have to collect the Social Security for you. So here it is that you are being mistreated in two different things. You are a non-resident for the immigration purposes, and for taking the money, that is Social Securities, you are considered a resident alien. Another interesting question that came out, Emily, that I need your attention is Chitra Adari. Oh, you mentioned the 20% plus denials of the H-1B. What are they going to do with the cap? Are they going to, how does it work in the cap, Emily?
Yeah, great question. So when they select the petitions in the lottery, you know, there's 65,000 regular cap and 20,000 set aside for the master's cap. They select extra petitions every year, knowing that a certain percentage are going to be denied. So last year, instead of selecting 85,000 petitions, they selected 100,000, or actually more, 115,000? I can't remember exactly. Yeah. But it was a large number more because they expected a larger number to be denied than they had in previous years. So I would expect even this year they're probably going to select a higher number in the electronic registration, accept all of the applications. They do still adjudicate all of them, but a certain percentage that they know they expect will get denied, they already take that into consideration when they do the selection.
Vikram has this question from YouTube, Facebook, that he has a H-1B and H-4 EAD options. Which one is better? One thing is that, Vikram, is that if I want people to be counted towards the H-1B number, because we are anticipating there might be some issues with the H-4 EAD in the long term, so you can always move back to the H-1B if you're counted once towards the H-1B number. If you're already counted towards the H-1B number though, previously, and this is just an extension or transfer which is pending, I would rather choose a H-4 EAD. Here is the reason for it. The denial rates for the H-4 EAD are absolutely not at all. I mean, 1%, I don't know which 1% it would be. And as I said previously, it's more than 20% of the H-1B that get denied. Second thing I mentioned before, that H-4 EADs can do multiple jobs. There's no restriction on what the H-4 EAD can do as long as it's a legal thing. You can't sell the drugs, of course, but you can do any job. You can do IT jobs, you can do a gas station job, you can be a Microsoft CEO, you can be flipping the burger in McDonald's. Nothing, I mean, all jobs which are legal jobs are eligible for H-4 EAD. When it comes to the H-1B, it has to be a specialty occupation, employee-employee relationship. The salary has to be a certain level. There are a lot of different, you must have an employer who must be sponsoring. You have a geographical limitation where you can work. And whenever you change, you have to file an amendment. So all those things are away if you are an H4 EAD. So if I have an option of H1B already counted, I would always go to the H4 EAD.
All right, I think we have time for one last question. This is from Pratik from Facebook. He wants to know about the new flag system for LCAs and is it causing any delays? So it is not causing any delays. We've not seen any LCAs taking beyond the normal 7-day processing time. It's just a different system, but the LCA form itself is exactly the same. The process is exactly the same. We've not really seen any difference at all in using the flag system, so no issues there.
And don't forget that we do have a daily conference call for you guys. It's free for you to come in and log in. Every day it's half an hour. You can check the timings at rnlawgroup.com. And don't forget to subscribe to the Emily's blog, which is immigrationgold.com, and also subscribe to Immigration News at rnlawgroup.com.
Thanks for joining us. We'll see you next week.
Thank you.